Welcome back to the Star Rock Murders. I'm your host, Andy Hale. I had so much fun last time with my guest, Sally Cohen, and I had her back for a part 2. And if you haven't seen part 1, Sally is a lawyer at Hale Monaco. She heads our wrongful conviction practice. She did her undergrad at Washington University in St. Louis, graduated from Harvard Law School, went the big firm route for a while in the litigation department, clerked for the Illinois Appellate Court, worked for the Office of the Appellate Defender's Office, and I'm so glad she's now with me working on post-conviction cases. Sally, welcome back.
Thanks for having me again. Yeah, it was a lot of fun last time.
So last time we took a deep dive into, we called it the legal autopsy, which I want to still have kind of a legal autopsy. We talked a lot about the law and the legal errors the judge got wrong. Today, I want to talk a little bit more about some of the facts in the case that was presented at the hearing, but I want to ask you first off, the judge I went back and looked at the transcript of the hearing. The judge made some comments about, well, this case is so old. Kind of explain what the judge said and what your take on all that was.
Yeah, so the judge, his comments there, and he asked us about this at oral argument, I think what he was sort of alluding to was the fact that, all our evidence was hearsay, right? Because there are not living witnesses that have the information that we were trying to present. So we had live witnesses, but they were testifying to things that people told them. And because he sort of based his opinion on the fact that hearsay is unreliable, he said essentially, because this case is so old, nothing I can do, which I found to be kind of the opposite of his role. And so I wanted to just point our legal eagles to a case that we cited that went uncited by the court, in which an appellate court basically says the opposite. He says, this is a murder case that is more than 20 years old, in which we have serious concerns that the wrong person may be in prison. There was no physical evidence tying this particular defendant to the crime, and the only witness against him was the girlfriend of somebody who was an obvious suspect. Basically, they go on to talk about how the older the case is, the larger the injustice is. So the more you have to take it seriously, because like I said on last week's episode, there's a serious concern with the wrong person being in prison. So his sort of attitude that, 6-year-old case, lock the door and throw away the key, I think is the opposite of the way that most courts would handle it. So I just wanted to flag that as another.
What was the name of that case? Do you have it?
That's People versus Class. If anybody would like to go look it up, 2023 ILAP first 200903.
I hope at least one person out there does. I hope somebody does.
I should also clarify in case anyone looks it up. It has been appealed. So hopefully the Supreme Court will agree with our position on this, but that's still pending. It's been pending since 2023.
So your take is basically it's the opposite of what the judge said. Because the case is so old, the evidence we were presenting is even more powerful.
Well, and especially the quality of the evidence that we were able to present from a case that's that old, and the consistency across it. I mean, it's just, to me, completely bulletproof. Not only did we present an alternate theory, but when you combine that with the DNA that the state preserved in an etched glass case, it's really actually surprising the quality of the evidence that we were able to present 65 years later, and the level and gravity of injustice. There should be certainly an interest in the state of redressing that wrong.
You said something that was a perfect segue into what I wanted to talk about next. You talked about how that case said, the older the case, the larger the injustice. So let me just pause here and take a deep breath. What we're talking about with the Starved Rock murders and Chester Weger, we're talking about what would be and what should be the longest wrongful conviction in U.S. history, by far. A man who spent over 60 years in prison, basically his whole life. Dirt poor dishwasher, arrested without probable cause, 21 years old, spending over 60 years in prison, and then dying at the age of 86. I just don't think you can have a post-conviction case in today's world more significant than this. I just don't think there's something, because of the length of time and the injustice. And what I want to talk about now is, last week we talked a lot about the judge's ruling. So I want to talk a little bit about the evidence. But in terms of the judge's rulings, the volume and the nature of, the things that we believe he got wrong. How do you characterize that? I mean, it's hard to believe like the judge just kind of got it wrong. It feels intentional to me, you know? Do you have a vibe about that?
So I'm actually going to quote from a different case now, which I think the way that the appellate court put the judge's conduct in that case applies here. The trial court turned a blind eye to much of the evidence and refused to admit probative admissible evidence that, when evaluated under the proper standard, is damning. Even where the court gave lip service to the standard it was supposed to apply, the court clearly did not adhere to that standard. The post-conviction court gave the impression that it was flatly unwilling to consider the evidence offered by petitioner. And I think that succinctly summarizes what happens here. The motivations, I don't want to speculate as to why a court would be flatly unwilling to consider the evidence presented by petitioner. But here, I think, in terms, including giving lip service to the standard, applying a different standard, I think all of that applies here. And clearly, reviewing courts are not pleased when a lower court does that. And here, I want to emphasize that we don't have the opportunity to appeal. So we won't have a ruling that says this. It's just our, cases that we gave the court that they should know.
Yeah, I just thought something. Do you remember as a little kid, my daughter Hannah really liked, remember the Madeline books? Mm-hmm. And they would be like, something is not right. There was a line of those books, like I think it was Mrs. Clavel would be like, something's not right. That's just the way I felt about this. Like, there's something not right here in terms of the way the hearing went down and the ruling was written. It just, we've talked about it. So I guess it...
Well, and I'd like to point out, sorry, not to interrupt you, Andy, but in this case that I just quoted from, and the same thing happened in class, when the appellate court is listing the errors here made by the judge, they make the decision to reassign it to another judge on for the next hearing. And usually you only do that in cases of evident judicial bias, and usually errors do not count as bias. But when the magnitude and the quantity of the errors is so significant, that can constitute bias. And I think we won't get a ruling on it, but I think we certainly have that here, given the way that these cases came down.
Boy, I would have loved to have got the opportunity to appeal and gotten a ruling. Oh my gosh. Well, we've talked about it. There's a lot of just stunning things we've talked about already. So I want to talk a little bit about the evidence, and I want to put this again in the context of what an important case this is. And let me start with Rule 3.8 of the Illinois Rules of Professional Responsibility, which state, the duty of a public prosecutor is to seek justice, not merely to convict. To seek justice. Keep that in mind. The prosecutor's duty was to seek justice. And here, the prosecutor's office we were dealing with was the Will County State's Attorney's Office. Okay. So I just went back through the evidence you're hearing and then the argument in some of the evidence. And I want to talk about some things that I think were either argued incorrectly or ignored. But this is the big one, and I don't know if I explained it really properly last week. So our judge is supposed to assess the strength of the criminal trial evidence, when he's comparing it to the new evidence. And so one of my arguments was there was evidence in the trial record that actually exonerated Chester Weger. I want to explain what I argued, and I'm going to read you what Will County argued, okay? So and this is in my PowerPoint slide, Dr. John Maloney did the autopsy on Mrs. Oding, and he testified at Chester's trial. And I'm reading from the transcript right here. And he said, I would say she had eaten within an hour or probably 30 minutes of having hemorrhaged in the mouth, which was aspirated into the lungs, okay? So within an hour or 30 minutes of having eaten, all right? So if we backtrack, and what I brought out was the fact that the evidence showed Esther Eichhoff testified. The women were checked in at 12:28 p.m. based on the tickets. And then she testified that they stopped by the desk just before going into the dining room for lunch 15 or 20 minutes later. So what I said was that would be 12:45 to 12:50, the women enter the dining room. And then what I said then was, let's say by 1:30, okay? Which means if they entered at 12:45 to 12:50, by 1:30, that's 40 to 45 minutes. They surely would have had some food in their stomachs by 1:30, okay? Which means Dr. Maloney's saying they would have, he thinks that they would have been killed within a half hour to an hour of eating. That's when the blood would enter their lungs. So that would be, if you take it at 1:30, that's 2 o'clock to 2:30, right? Are you with me so far?
Mm-hmm.
2 to 2:30, okay? Well, in the same criminal trial, Emil Bohm testified he saw Chester in the men's bathroom at like 20 to 3. So at the time, the blood is, according to Dr. Maloney, in the women, in Mrs. Oding's lungs. Chester Weger's still at the lodge. And I argued that actually proved his innocence. And again, that would have been evidence in our favor presented at a retrial. And can we create reasonable doubt? I mean, that right there, I think, would have been strong evidence to show reasonable doubt. This is how Will County argued it. Will County didn't even understand what I was saying. This is how they argued it. I'm reading from the transcript. But then they rely on more speculation, more assuming. I mean, look at their timeline. 12:45 to 12:50 lunch. I guess they ate in a 5-minute span. No, that's not what I said. They ordered food. The food came out, they ate, left in that 5-minute span. Completely rules out them sitting and talking and having conversation regarding coffee. Completely rules out that maybe the food took a while to be made. No, they just want to inject more speculation into the evidence. No, what I said was 12:45 to 12:50 was Miss Eichhoff said they came back, they checked in at 12:28, and they came back 15 to 20 minutes later. And he says, I don't know, this isn't speculation. Dr. Maloney, and he talks about Dr. Maloney, how long he said it took for the women to go into shock. That was separate testimony. Mm-hmm. That was separate. Yeah, 2 hours to go into shock. This was, but he testified how long it would have taken, for the blood to enter the lungs, how soon would they have eaten. So Will County didn't even argue this correctly, didn't even understand what I was saying. And this gets lost in the shuffle. Did the judge even bring this up in his opinion? This timeline issue?
Right. No, I mean, I think the reason not, like, he sort of swept it under the rug with everything else that was, available at the trial. The timeline, if it was evident from the state's evidence at trial and the jury arguably heard it, well, we're not going to address this at all in this opinion, except for insofar as it corroborates Chester's guilt.
I mean, this was such key medical evidence coming from the doctor. I mean, saying that she would have eaten within an hour or 30 minutes of having hemorrhaged in her mouth. Mm-hmm. So if we know she would have eaten by 1:30, she's hemorrhaging in the mouth by 2 o'clock or 2:30. I mean, it's so powerful. And again, this doesn't have to prove Chester's innocence, but it is strong evidence creating reasonable doubt that just Will County, you heard how they argued it. They argued it completely incorrectly. And then the judge just ignored it, And I thought that was I thought it was such a huge point that got swept under the carpet. I just want to make that point again and again and again. Now I want to talk about the mafia. And so we had, let me first set forth the way Will County argued it, and then I'll tell you what our evidence was. Or maybe I'll do it backwards. So we had evidence that Roy Tyson said Smokey Rona told him he was approached by the Chicago Mafia to organize these murders. Melissa Smith said her grandfather was in the mob, organized, the guys went down there to do this. We showed that Lupe Cardenas, who was always in the bar with Glenn Palmatier, had ties to the Chicago Mafia. We know Mrs. Murphy's missing a fingertip. And here's the kicker. After the hearing ended, but before the argument, the argument was not for several weeks later, we sent Will County evidence that Melissa Smith's father's brother, so her grandfather was Roy Grizzy, His brother Al Grizzy, this is an email from May 19th, 2025, and I sent this to Will County. Newspaper articles from October of 1961, and I'm reading from the Chicago Tribune. Meanwhile, the name of the crime syndicate's Northside vice boss, Jimmy the Monk Allegretti, popped up at a hearing to revoke the liquor license of the Devonshire Lounge, 19 East Ohio Street, described by police as a hangout for prostitutes. And another article was saying Al Grizzy was the licensee of that Devonshire Lounge. Al Grizzy's bio says he was born in Chicago, was a retired food and beverage director in a casino, and was an 18-year resident of Las Vegas. Okay, so Al Grizzy, back in 1961, has got some ties with the Chicago Mafia. We presented this evidence from Ms. Tyson, Ms. Smith, Lupe Cardenas. This is what Will County, this is how they argued it in the argument. I'm just going to read this. I want people to get a feel and a tone for this. And when a party has no evidence, when the facts are against them, the easiest thing to do is to reach for a conspiracy. And they did. The Mafia did a conspiracy. There are few conspiracy theories that are more convenient than the Mafia did it. I mean, invoking the Mafia is simply just an attempt to inject confusion, speculation into a criminal process that demands clarity, logic, proof. To be honest, it's a lazy theory because it doesn't involve any real evidence. It just relies on innuendos, on hearsay, on these suggestions that these shadowy figures are pulling the strings behind the scenes. I mean, that kind of theory plays well in documentaries, but not in courtrooms, because in here we don't deal with plots, with paranoia. We deal with facts and evidence from a witness stand. The facts in this case, they don't support a Mafia hit. They don't point to a secret organization. The defense is just simply choosing to chase ghosts rather than confront the actual evidence in this case, because the actual evidence tells a completely different story. This is a complete issue of competent evidence. The defense presents a conspiracy theory, a fable, an urban legend. I was on the edge of my seat when Miss Smith and Mr. Tyson were testifying and how they were going to tell us how the Mafia killed JFK. I mean, I just think that is, I'm trying to pick my words here, you know, not only inappropriate, but it's condescending. It was so, what's the right word? What's the word you would use? I mean, it just, the way it was kind of mocked, the whole Mafia thing was just mocked, you know? I mean, and that was the tone.
Live, sorry not to interrupt again, but the disdain in the state's prosecutor there, his voice and his tone, it was beyond condescending and mocking. It was, yeah, I mean, I do struggle to find the words. We've struggled to find the words last week too.
I mean, I just want people to understand, you know, it wasn't like I was saying Mafia with no basis whatsoever to say Chicago Mafia. And one of the things I didn't even bring up that the judge, you know, wasn't part of the new evidence, there was a newspaper article on the 40th anniversary of the Starved Rock murder. So this had been like 2000. And Harlan Warren, the state's attorney, was quoted as saying, yeah, you know, the Illinois State Police, I thought they knew what they were doing, but they first thought the Chicago Mafia was involved. Oh, really? The Illinois State Police thought the Chicago Mafia was involved? Huh. Interesting, you know? So, you know, to dismiss the Mafia thing as this made-up fairy tale, I just thought was really, really stunning the way Will County argued that. Let me transition to the hair, what they talked about the hair. This is what they said about the hair. This hair, like a rumor, has taken on a life of its own. The hair that no one knows where it came from, no one knows who recovered it, no one knows who's handled it, no one knows where it's been for 60 years. But the defense wants to rely on the front of an envelope to establish that it's from Mrs. Murphy's glove. The same front of an envelope that initially indicates there were two hairs. Well, we don't know who wrote that. The same front of an envelope that says one of the hairs went missing twice. We don't know who wrote either of those notations on the envelope. But somehow, after 60 years in that envelope, there's a full hair in that envelope and 3 fragments of a hair. Okay, let me pause. So all he's talking about is the envelope, the envelope, the envelope. You know, the envelope basically says it's hair recovered from the left index finger of Francis Murphy. But what he doesn't mention, which I did in my argument, and I showed the photo, this hair was between 2 glass slides, and it was etched in glass that hair came from the left index finger of Francis Murphy. It was etched into the slide. So yeah, it was meticulously labeled. So to argue about the envelope and the writing on the envelope, it matched. It was found in the envelope where it should be. I mean, I just felt like that again was. I don't know. It's hard for me to choose the right words on this podcast. I would probably choose some other words if you and I were just talking privately. I just felt it was inappropriate. It was not. I didn't think it was a fair characterization. So you heard about how they handled the mafia, how they talked about the hair. Let's talk about Lois Lensek, the telephone operator. They didn't say too much about her, but this is what they said with the transcript, page 122. What does this phone call mean again? ? It's just more speculative, unverified, unreliable hearsay, all on top of each other, and that's why it makes zero sense. I mean, like that's it. I mean, it just ignores all the detail that Lois Lensek provided, all the credibility found in the memo. Her struggle, she knew it was supposed to be confidential. The Aurora police found it to be reliable. The Illinois State Police found it to be reliable. They traced the call. I mean, again, just to handle the evidence that way in such a shallow, kind of flippant way. And I thought the telephone operator member was such huge evidence.
Me too. And it didn't make no sense. It made a ton of sense. It was the linchpin to a theory that makes complete sense. I think everybody that pays any attention to the evidence can see the through line from every piece of our evidence, from lubicadenus to the DNA.
Here's another thing I wanted to point out. In my argument, I was talking about how all the different ways Chester's air quotes confession didn't match the physical evidence. And one of the things I pointed out was Chester, in the so-called confession, basically said that this limb broke, that it broke. And it broke, he said it a couple times, the piece broke off. The club broke, like there were two pieces. And there was nothing. I mean, the log this limb was a piece of evidence at trial. It wasn't broken. It wasn't in two parts. It wasn't damaged. And that, any one of these points is so big on its own. We have so many that it gets watered down. But the fact that Chester's saying that this limb broke and that it broke into a couple different pieces, and that the evidence at trial, that limb was not broken. And nobody said that at trial. And that didn't even get addressed by Will County in the argument or the court. That just kind of went untalked about, All Will County really said, one of the things they said was, the log, there's splinters in Miss Oding's head that matched the log. Yeah, there were a couple little pieces of bark that got taken out with tweezers. What our forensic pathologist, David Fowler, said was, you'd have had bark all over these women's faces and heads. The bark would have been, the log's getting damaged, There would have been bark everywhere in these wounds, and there wasn't. Do you recall that?
Yes, I also recall the notes from the meeting with the forensic scientists from way back in the day that is still newly discovered because it wasn't turned over, where the pathologist noted blood on limb did not result from hitting.
Right.
So it's sort of the same concept. Yes, there would have been tons of blood on the log. There was some blood on the log, but it didn't come from hitting. So where's the log that the blood on it came from hitting? Where's the actual murder weapon?
And this is what David Fowler, he said, our forensic pathologist, said, you'd expect the bark to be peeled off. You'd expect there to be evidence of bark in all the wounds, which there wasn't on the women. You'd expect there to be damage to the log. That point just kind of, fell on deaf ears. Here's another point. I thought this was kind of telling. At two different times, the court asked Will County whether evidence found on... So, the trial was just the trial of Mrs. Oding. That was what Chester Weger's trial was. He was charged with her murder. And the court at basically page 150 and 153, this is what it said, if it was on the glove of an individual whom he was not convicted of killing, is it relevant in the state's position for the court to even consider that DNA evidence in the context of the Lillian Oding murder? And Will County said, Judge, we would say it's not relevant. And then on page 153, the court said, should the court consider evidence in relation to a body that he was not convicted of actually killing? And the state says, the state's position is no. What do you think about that?
I think a lot of the arguments that were made by the state, maybe most of them, were not made in good faith and certainly not in line with their professional ethics to seek justice. Certainly, I made this point last week that they know the relevance of the evidence, and if it had been useful to them, they certainly would have used it. And the relevance of evidence goes both ways.
I mean, that's like saying we've got exonerating evidence on Francis Murphy or Mildred Lindquist. We've got DNA evidence. Let's just say we had semen, okay, on either of those bodies. They're saying it's not relevant. When what the state argued and what the confession was, that one person, Chester Weger's confession was he killed all three of these women in rapid fire succession. At the trial, the state brought in all this evidence of how all three women were killed together at the same time. For the state to end at our hearing to say that anything found on the other two women is not relevant, I thought that was stunning, just stunning. Let me talk about the twine. This is what the state said. They said, the twine. The defense argues that there was no corroborating evidence regarding the twine. 20-ply was found at the crime scene. And Chef Kamadi, who works at the kitchen, says that there's 20-ply also located at the Starved Rock kitchen where the defendant works. And they did talk about the twine. The state did talk about the twine in closings. Let me read you, and I hope I'm not belaboring this, but let me read you from something I've written called The Tale of the Twine. This is what I said. This extremely weak trial testimony regarding the 20-strand twine and Attorney McNamara's effective cross-examination of these witnesses must have caused the state to abandon making any claim that the 20-strand twine found around Miss Oding came from the lodge, as all Mr. Richardson could muster during his closing argument on the issue was the following, quote, so they went into the cave, or by the cave on the rock, sat there and allowed themselves to be tied. With what? With string. What kind of string? 20-ply cord. This man has a propensity for carrying string in his pockets. That is brought out in this case. End of quote. So what I say is, thus the state abandoned any argument that the 20-strand twine found around the wrist of Mrs. Oding was the same type of twine used at the Starved Rock Lodge, and instead weakly argued that Chester Weger had a propensity for carrying twine in his pocket. Hardly a persuasive argument. But this is what I point out too. McNamara, in his closing, didn't let it go. McNamara knew that this had been a big issue that the state claimed they were going to present evidence of, and they didn't. So McNamara said, now let's go to this string. Now this string, which was identified as being on the wrist of Mrs. Oding, the victim in this case, can be dismissed as a common 20-ply butcher twine, which is common throughout the entire world and has not been tied into this case or in with the defendant in any way, aside from his confessions, which he has denied as being completely involuntary and is partially told to him by Deputy William Dummett. In fact, as will be shown later on when his home was completely searched, the only string that was found was 12-ply string, and that string had no connection to this case at all. And McNamara didn't want to explain this. And so for the state to say, the state did talk about the twine in the closings. Well, no, not really. Not in any way connecting it to the lodge. So that was not accurate. There was nothing at the trial connecting the twine to the lodge or to Chester Weger. Now, let me just read you some parts of the final summation of the state. Again, in the context of a case that's potentially the longest wrongful conviction in United States history, okay, where we've got DNA evidence, genetic genealogy, all this stuff. Okay, I'm going to be reading parts of pages 146 to 148. Not necessarily consecutively, but parts. And for those unfamiliar, because this isn't the internet, that's beyond a reasonable doubt. That's fact. No speculation, no spin. All the defense has is a dramatic story, a conspiracy theory involving the mafia, a strand of hair with a bigger story, and hearsay. And it's an interesting story, but that's all it is, a story. It might be entertaining, but it doesn't exonerate, because the law demands more than speculation. It demands proof. This is not a novel. It's not a podcast. It's not a documentary. This is a courtroom. And in a courtroom, the evidence speaks. And the evidence says the truth is the defendant killed Mrs. Oding just like he confessed multiple times. And by the way, in a court of law, there's another way to phrase a foundationless speculation-only case, and that's no case. And so that's, the state spent more time kind of mocking my efforts to develop leads and information by having a podcast, by reaching out to people, trying to find people with knowledge. There was such disdain and mockery for my efforts to find people who might know something, that was really, really disappointing. And that's probably that's just way, way too generous of a term to say disappointing. It's a lot more than that, but disappointing to think that they would be mocking me and my efforts for the work that I did and the time and effort I put in to try to develop evidence supporting our case. So I just wanted people to get a little more flavor and flair for the way the case was argued at the oral argument. And again, in a case where this should have been the longest wrongful conviction in U.S. history. And in my eyes, it's such an egregious, unimaginable injustice. It's just stunning. So before we move on to another topic, is there anything else you want to say about kind of the hearing, how it went down, what we talked about so far?
Just that the state, especially in summation, they replaced any analysis or treatment of the evidence with histrionics and dramatics and, accused us of having no case and just using innuendo. But usually when you're sort of taking insults and petty shots at the other side in your closing argument, it's because the evidence doesn't support you. So I thought that it was professionally improper as well.
And what's again, we're preaching to the choir here, you and I. I mean, and I don't want to sound like a whiner or a crybaby, but it's an outrage. It is an outrage. I just think the whole way this went down is an outrage, and I'm not going to be quiet about it. I'm not. I'm going to talk about it, and I want people to know what went down. It's one thing, when all those arguments were being made at the oral argument, it really didn't bother me because, like you said, I just thought, well, this is weak. This is weak. I mean, yeah, I'm sure like Will County all went outside in the hallway and high-fived each other like, boy, you really gave it to Chester's lawyers. But I don't think that's effective advocacy. I'm like, I don't think the judge is going to buy any of this. But then when we got that opinion, because I didn't think anything Will County said was persuasive at all. It didn't bother me at all. I just sat there, let them, do what they're doing. But then for the judge to rule against us in the fashion that he did, that's the part that was even more stunning, as we've talked about. So to be continued on that front. You and I are working behind the scenes. I'm not going to get into yet kind of, our efforts, but we are, we are exploring our options and we are working. We are continuing to work. Let's talk a little bit about, did you want to talk a little bit about constitutional issues?
Well, I did, but before we dive right into that, there was one thing that I wanted to raise in terms of sort of facts that didn't get brought up in the trial that I believe were we weren't allowed to bring in, but you can correct me if I'm wrong on that, Andy. But I just wanted to highlight, the judge's treatment of our, according to him, sort of frivolous argument that Dummett had, coerced the confession and that the plain evidence was so corroborative because nobody besides the true killer could have known about this plane flying overhead. Well, lo and behold, there was a case in 1980 in which Will Dummett was found to have perjured himself. A defendant accused him of coercing a confession and suggesting the way that the crime had happened by showing him crime scene photos, just like Chester did, and telling him what to say in his confession. And of course, Dummett denied having done this, but the defense team was able to get the sheriff's office to go through Dummett's desk. Lo and behold, found the photos, found the film reels that he claimed he never possessed and never had pictures of. So in that case, it resulted in the granting of the suppression motion. So there was later evidence, of course, that's 1980, decades later, of Dummett having used the same tactics that he did against Chester in another case. So for the judge to say, to accept this, that Dummett would ever do such a thing when there's evidence of him doing the exact same thing was, again, just being willfully blind to the evidence. And Andy, correct me if I'm wrong, that we had brought this out earlier, but it was not allowed to be part of the hearing. We
basically argued that, Dummett had a pattern and practice of doing this kind of misconduct. And oftentimes in cases, especially in cases in the city of Chicago, pattern and practice for some of the Chicago police officers in these post convictions is admitted, in cases, if somebody's had allegations of wrongdoing in multiple cases, it's admitted. There's a lot of stuff that didn't come in. And the other thing too is, we were in the post conviction court, but just to be clear, Will County, as the state's attorney whose job it is to seek justice, can look at all the evidence, everything out there, old and new, and decide what is justice, what they want to do. So it's not like Will County could not consider things that only came up in our case. Will County at any time had the authority to vacate Chester's conviction based on all the evidence. There were so many other things that didn't get brought into our case, like the handwritten notes of Harlan Warren, where he had, the notes about get the man to confess, commence psychological warfare, things that technically, we weren't allowed to bring in, old newspaper articles talking about this being a crime of vengeance, on and on and on. So I think as time goes on, I'm getting even more kind of blown away by how overwhelming our case was and, kind of where we're at. So I'll turn the floor over to you. What do you want to talk about next?
I wanted to flag for the listeners a few of the constitutional claims that were dismissed. So ultimately, at the third stage hearing, we were only permitted to present the argument that Chester was actually innocent. So that's a separate type of claim. On post-conviction, you can also bring claims that say that your conviction is the result of constitutional violations at your trial. But you can do that in a different way on direct appeal. But in a post-conviction motion, you'd be using evidence that shows that would not be on the face of the trial record. So essentially, let's say you have evidence now after trial that the jury was bribed. I mean, that's an extreme example, right? But that would be in violation of the Constitution. Or you have evidence that your defense attorney had a conflict of interest that you weren't aware of, or all sorts of things that usually something happened outside of the trial that resulted in your conviction being unconstitutional. So we had several claims relating to constitutionality of Chester's conviction, starting with, as Andy already mentioned, that he was arrested without probable cause. As the listeners, I think, know, he did not confess until after he was already arrested. There was no evidence besides his confession that would have tied him to the crime at all. So there was no physical evidence, there were no witnesses. So to have probable cause, you have to have specific facts and circumstances that would lead a reasonable person to believe that a crime has been or will be committed, or that the person has committed that crime. So you basically need specific evidence. It's not beyond a reasonable doubt, but it's above a reasonable suspicion. It's probable cause. And so typically you get a warrant. You need a warrant to arrest somebody. Here, they got a warrant not from a real judge who would assess probable cause, but from the justice of the peace, which was a local grocer in this case, who had never been asked to issue warrants at all, let alone for murder. So the court basically said, well, they had a warrant. So he wasn't going to look at the underlying facts supporting probable cause because a judge, justice of the peace, technically found there to be probable cause, and he wasn't going to re-review that. That's the first constitutional claim that was clearly, I mean, it's just really obvious to any person who's looking at it that there was no probable cause to arrest Chester for 3 murders. And then they used that arrest to get the confession out of him because that was sort of their last, what's the phrase?
Well, it was like the last little trick, It's like it was like they played their final card.
Yes, they played their final card. They hadn't been able to get a confession out of him yet, and that's what they did. Certainly those confessions after the arrest without probable cause would have been tossed in the modern era. So that's another thing that I wanted to talk about, which is the legal landscape at the time of Chester's conviction was much different than it is now. So in the first way, I think a lot of people listening to this will be familiar with the case Miranda versus Arizona, especially if you watch Law and Order, because that is where you get your Miranda rights. Miranda is a landmark case from 1966 in which the Supreme Court held that law enforcement must warn a person of their constitutional rights before interrogating them, or else that person's statements cannot be used as evidence at their trial. So basically they have to be informed that they have the right to consult with a lawyer and that anything that they say can and will be used against them. So in order to use a confession procured through an interrogation, the state has to show that they made the defendant aware of those rights or that he voluntarily waived those rights when he gave his confession. So Miranda is really important because it marked a shift in the way you treat confessions and interrogations that lead to confessions. Before, it was really on this defendant to prove that their confession was involuntary. And after Miranda, it was the state's burden to show that they conducted the interrogation in accordance with the Constitution. So you can see just 5 years later how differently his confession would have been treated had Miranda been decided. Miranda does not apply to cases that happened before Miranda, but like you were saying, it's the prosecutor's duty to seek justice here. And if you can tell as plainly as we can that the confession was the result of coercion, and when we have the whole expert testifies to coerced confessions, it should give the state in the modern era, certainly when it was known in 1966, certainly now, the state should be able to see that the whole process did not comport with the Constitution and was likely going to return a false confession. So that's one claim that we couldn't really make, which is that his confession should have been suppressed because it was involuntary. The other really important constitutional claim here is about the suppression of evidence. So another case that people might be familiar with is Brady. That's from 1963, Brady versus Maryland. And that is where the court held that the prosecution's suppression of evidence violates the 14th Amendment. So basically, the state has to turn over exculpatory material evidence to the other side. In this case, Andy, I can invite you to go through all of the evidence that was exculpatory and material that the state did not turn over at trial or before trial or even long after trial. And I just wanted to point out here that Brady did not come out of nowhere. The duty to turn over exculpatory evidence when requested existed in different forms, basically since 1935. The deliberate use of perjured testimony was deemed unconstitutional. And then the denial of evidence in post-conviction context was also deemed unconstitutional in 1942. So there were duties, like Brady didn't come out of nowhere. And so the fact that Brady didn't exist doesn't mean that the prosecutors, even at the time, didn't have the duty to give us exculpatory evidence. And so the judge there basically said, well, Brady didn't exist, and tossed that claim when, if you peek under the hood, there's a lot of stuff there that the judge should have and could have considered in terms of the denial of his constitutional rights at his trial.
You're talking about our judge.
Our judge.
Yeah. Those were big issues. Any others?
Those were the main ones in terms of the constitutional claims that were improperly tossed. I could get into the weeds on other ways the judge could have tossed them, but on the merits, they should have been able to go forward. They are really old claims. It is difficult to litigate a constitutional claim that far after the fact because of various reasons and the way that the test is set up. You have to sort of show that you couldn't have brought it earlier, and earlier, where does earlier start?
Well, and remind me too, which opinion is it? Is it Brady versus Maryland, or is it Miranda versus Arizona that mentions John Reed?
It's Miranda. Yep, that's actually a really good point to bring up here.
What's your recollection of what? Because just for the listeners, John Reed. So what happened was, for the first several months in the investigation, all the polygraphs were given by polygraph examiners who worked for the Illinois State Police. So, the murders are in March, April, May, June. It wasn't until September, late September, after the Palmatier brothers have evaporated, that Harlan Warren says, you know what, I'm going to start my own investigation. And he gets deputies Dummett and Hess. And these three guys now are the ones kind of running the show. And Harlan Warren doesn't use the Illinois State Police polygraph examiners. He brings in John Reed and Associates, a company based in Chicago. And there was a guy who worked at it by the name of Stephen Kindig, who we showed through newspaper articles, knew Robert Murphy, the husband of Francis Murphy. So that's a massive red flag. So Harlan Warren brings in John Reed's company and John Reed himself to do these polygraphs. Tell me what you remember the Miranda case saying about John Reed.
So the Miranda opinion cites John Reed, or refers to John Reed in like 8 footnotes of the opinion. So Chief Justice Warren describes John Reed's techniques very negatively in the Miranda opinion. He says, the setting prescribed by the manuals and observed in practice becomes clear. In essence, it is this: to be alone with the subject is essential to prevent distraction and to deprive him of any outside support. The aura of confidence in his guilt undermines his will to resist. He merely confirms the preconceived story the police seek to have him describe. Patience and persistence, at times relentless questioning, are employed. To obtain a confession, the interrogator must patiently maneuver himself into a position from which the desired objective may be obtained. When normal procedures fail to produce the needed result, the police resort to deceptive strategies such as giving false legal advice. It is important to keep the subject off balance. For instance, by trading his insecurity about himself or his surroundings, the police then persuade, trick, or cajole him out of exercising his constitutional rights. So, Chief Justice Warren is describing John Reed's techniques when deciding that you must be informed of your right to an attorney. There are all these procedures that you need to follow in order to get a confession through an interrogation because of this exact type of thing that was used against Chester. And clearly the Supreme Court, just a couple of years later, is gravely concerned with the type of treatment that Chester received.
And think about this. So when Chester gets picked up early that morning in late September, taken to Chicago, he's there all day till like midnight. So to actually administer a polygraph exam, to actually administer the exam, hook them up to the machine, ask the questions, that's going to take an hour, let's be generous and say 2 hours. What's going on the rest of the time in Chicago? I mean, what's going on the rest of the time? I'm sure the rest of the time they're just interrogating him, badgering him, cajoling him, pressuring him to confess. And then when he's done at midnight, they don't drive him home. They drive a couple hours back to LaSalle and they take him to the courthouse in Ottawa, to the state's attorney's office, and they continue to interrogate him. So they're trying to they're trying to extract a confession from him.
They didn't just take him to, Chicago's best interrogator. They took him to the person who literally wrote the book on how to get a confession out of somebody.
Yeah.
So it's outrageous that's, he passed all these polygraphs before, he never confessed before, and that shows the lengths they were willing to go. I mean,
in September, so end of September, there's nothing linking Chester to these crimes. So the fact that they took him to Chicago and pressured him all day and then drove him back home and pressured him and interrogated him all day just shows you they were clearly trying to break him down and get him to confess. And what he testified to at cross, I thought this was really mature and insightful. Reculia on cross, State's Attorney Reculia was like, well, he didn't confess, in Chicago, He's like, well, I wasn't under arrest at that time. What he said was, that just showed you the pressure. When they played that final card, he's now got handcuffs on, he's in jail, and he's been charged with 3 murders. So now the threat that if you don't confess, you're going to ride the Thunderbolt, the threat is real because he's been arrested. Mm-hmm. Before that, he's like, well, I didn't do it. There's no evidence linking me to it. But that's what was so evil about what they finally did. And that's when I go back to everybody knew there was no evidence tying Chester to the crime at the time he got arrested, right? And so, you don't see this kind of conduct with the Palmatier brothers. You don't see the Palmatier brothers getting dragged to Chicago for an all-day session and interrogated and then brought to the state's attorney's office and all these things. And by the way, the Palmatier brothers would have just said, no, we're not going because you didn't have to. Chester Weger, this dirt poor dishwasher, unsophisticated, he didn't have to do any of this. But he did because he knew he was innocent. He didn't have to go to Chicago. He didn't have to do all these interviews and all this nonsense, but he did, and it's so, Sally, it's just so egregious. And that's why I go back to the way Will County argued the case in terms of tone, argument, and even the way they handled the case from the start, basically mocking it, kind of just like, just the whole way it was presented in a case that was so serious and had such serious facts and serious evidence, it's just, again, stunning is a good word that just keeps coming to my mind. So is there anything else you want to say before we kind of start to wrap things up? You can keep going. I'm in no hurry.
On your last point, I mean, I think it's interesting, and it sort of puts Chester certainly in a double bind. With regard to the original suppression motion, when he was arguing that his confession was involuntary because it was procured by threats of violence, the Thunderbolt thing, and ultimately the court said, well, those threats were made on the drive back to Chicago. You didn't confess until X, Y, and Z time later. So those threats your confession could not have been the product of those threats. So bingo bongo, it was voluntary. But I think, as you're pointing out, Chester made the point that the threat was the arrest. The threat was made weeks earlier about riding the Thunderbolt. That threat is implicit in the arrest for 3 murders like this.
Right.
And when you look at the interrogation tactics that are laid out by this manual, and it's talking about patience, comfort, do all these items that don't really occur at one time that produce a coerced confession. And I think the fact that it occurred over such a long period of time for that then to be said that was not coercive, when clearly that was the coercion, they were relentless, right? So just because the physical threat of violence occurred earlier in time, it was just building and building and building. It was getting worse and worse. So I think that's really unfortunate that the court didn't see it that way. I mean, obviously.
And then you go back to the Palmatier brothers when they traced the call. So like I said, Glenn Palmatier may have been telling the truth when he said he wasn't the one who placed the call. It could have been Lupe Cardenas, right? It sounds like it was Lupe Cardenas in terms of big burly guy, limited vocabulary. But William Palmatier can't make that claim. William Palmatier received the call. Mm-hmm. So he received the call. All he could say was, we never talked about those things on the call, which is a lie, which is just an absolute lie, because the operator heard you say those things. She heard you talking about card transactions. She heard all this stuff. So it's so clear that, and then Glenn Palmatier's interview is August 30th. It's September 1st that Craig Armstrong writes this profuse apology letter. Oh, we're so sorry. Like, the brothers get these apology letters, we're so sorry you got dragged into this. Like, what's going on here? Mm-hmm. I mean, why are we apologizing to these guys based on nothing, And so it was so clearly a cover up. I just feel like nobody has had the courage from 1960 till today to stand up and to call it for what it is. Nobody's had the courage to cite the misconduct, to cite the wrongdoing, expose the misconduct, and set the record straight and show what the real truth, what justice is. Nobody's had the courage from the time those women were murdered until today. And there was a colossal injustice that happened when Chester was arrested. There was a colossal injustice when Chester got convicted. And there was a colossal injustice when Chester's post-conviction petition was denied. And it's a continuing colossal injustice. But we will continue to do our thing. We will continue to be out there fighting the fight, battling the battle. Rest assured, we're not going anywhere. And I urge anybody out there, if you know anybody, if you got some relatives from that area, aunts, uncles, grandmas, grandpas, talk to them. Find something out. I mean, there's no tip that's too small. I would still love to hear more information that anybody has on any topic, even if it's something that you think might not be important. It actually could be. Reach out to me, please. Sally Cohen, great to see you. Great talking with you. We could chat all day. I think this case warrants this kind of legal autopsy. It's such an important case. I think we need to continue to talk about it. We need to continue to make people aware of it, what the facts were, what the evidence was, what the law was, how it got ruled on. It's such an important case. So I think we'll continue to talk about it. So I hope to see you soon and to be continued.
Yes, looking forward to it. Fighting the fight.